Thank you, Simon, and good afternoon, everybody. So we want to talk to you today about our experience of developing a new public law course in which we were looking at challenging traditional approaches. So I'm going to explore those experiences where we try to offer a new and fresh approach to the teaching of public law, and central to that approach was exploring legal history, and that has helped us to enrich and diversify the curriculum in ways that aren't reflected in the standard texts on the topic. And one of the things that we're trying to do is to engage students in different ways and to challenge their assumptions and traditional approaches to public law. And I wanted to bring in some imagery here, going beyond the text, because as an online module, we do tend to break this up with imagery. And one of the challenges that we faced were that many of the standard textbooks, for example, weren't necessarily inclusive of all nations within the UK. So for the module image, we chose the UK Supreme Court carpet, as the UK Supreme Court is the final court of appeal, but also has imagery which reflects 4 nations. Now, 211 is at Open University Level 2, the equivalent to a second year in a traditional university. It's around 300 hours of study, and it's taught from October to March. It's compulsory for our LLB students and our joint degree students with criminology and also languages. It's assessed by a number of tutor marked assignments and by an end of module assessment task, all of which have been designed by Simon to develop independent research skills. And our students can choose to study at a part-time or a full-time intensity rate. Now, we haven't just taken one approach when we've built in the histories of this module. So we explore the history of the United Kingdom. We also look at the histories of the nations within the United Kingdom to see the journey that we've been on, so England, Northern Ireland, Scotland and Wales. And then we look at some very specific examples, such as the Windrush generation and scandal. We explore briefly the history of the Nazi state of exception. We look at the history of the relationship between the United Kingdom and the European Union. We touch upon the history of British Empire and decolonisation. We also look at the fact that the history of public law is also the English textbook tradition. And we also challenge and consider towards the end of the module the sort of the traditional history of judicial review. So we've achieved this by developing a number of resources, and the first one has been the use of interactive timelines, enabling students to explore and filter those timelines. So, for example, they can filter by nation or by constitutional statute to find the information, and then look at historically how that has developed. And visually, sometimes this means on the timeline there are large gaps, whereas in other decades there is lots of information together. So it gives a feel for the pace and of change. We also talk about the impact of law on society and vice versa. So, for example, it's often taught that we have a constitutional monarchy, and we touch very little on the fact that there was a Commonwealth, there was a republic, and so we expose them to some of the ideas behind that republic and explore why that experiment failed. We look at liberating the curriculum by bringing in examples from across formerly colonies, and we're very transparent about what we're doing and why. We've also built in the opportunity for students to have an element of choice. So for a number of units, they have that opportunity to look at something that's more state or more nation focused. And through developing their independent research skills, we enable them to go and look at topics that are of particular interest to them in order to engage them. We also have an interactive constitutional bag, so students can choose what they want to put into the constitutional bag, and at relevant points they can take things back out, or they can add more in. And the idea is that throughout their studies they're thinking about what they would want to see in a constitution, what they wouldn't want to see, and this is gradually built up through a picture of sort of starting with some of the basics and then layering on the complexity and myths around the Constitution. It's very much a critical approach and taking different perspectives, and also doing some comparative work by, for example, considering the approaches of constitutions in India, in Ecuador, and looking at whether those approaches could be ones that we could think about in terms of the values and rights. And I now want to move on to focus on a couple of specific examples. I'm going to look at the history of the nations, and then my colleague Simon is going to consider the legacy of empire. So just touching upon the Open University for a moment, because as a law school we are in a unique position because we have students in all areas of the UK, and the mission of the university is to be open to people, places, methods and ideas. So this fits very well with this liberating, critical approach that we've adopted. And the vision of the university is about life-changing learning that enriches society. And as a Four Nations university, we have a role in looking at the Constitution more widely beyond the traditional remits. And also underpinning all of this is the fact that the OU Law School offered its first law course in the same year as the 1998 referendums. So the development of the law school has kind of shadowed the development of legislatures within the four UK nations. And one of the things that we get them to pause about is to reflect on their own knowledge and experience, because terminology becomes very important. Are we talking about England, about Great Britain, about the UK? By England, has the terminology been used incorrectly when actually it's meant to incorporate, for example, Wales and Scotland and so on? We look for historical explanations. We look at the histories, and we look at standard texts and then actually texts from the other side, so that students can reflect and be encouraged to develop their own perspectives and knowledge around these, but gaining that understanding of their own bias that they might come with. And it's about understanding how we've got to where we are and the events and information that's gone behind that. So we've got that background and context. And the emphasis is not just on knowledge, but on the skills, enabling students to go and find that information and analyse it for themselves. So in terms of the work that I've undertaken, we've looked at the Four Nations and human rights because of the differing human rights approaches that are now apparent between the UK government, the government in Wales and Scotland, and in Northern Ireland when there is a functioning executive. We also look at the UK's constitutional background, so we go right back through history. It's often overlooked that Wales, before Edward I, had a codified, thoughtful, just legal system, which is not much known maybe beyond Wales. We look about the unions and how they took place and the reasons behind them, looking at the societal reasons, not just the legal reasons. And we look at the history of rebellion within Ireland and the creation of Northern Ireland, leading to the creation of the United Kingdom itself. And then we want to engage students with where next, so that they're looking at what possibilities there may be going forward should the UK become federal or remain as a loose confederation. What are the different opinions? And here we can touch upon the political influences as well as the constitutional ones, because it's about equipping our students with the necessary knowledge and skills for them to form their own reflective points and to be able to argue their own case for change. And having very briefly and speedily gone through that, I will now hand over to Simon, who's going to consider the legacy of empire on the Constitution of the UK.
Thank you, Carol. Yeah, I've got to hone in on one particular unit. Some aspects of this are mentioned, brought up earlier in other units, but one particular unit that focuses on this question of, I suppose, the decolonising constitutional law through its history, and that's the unit 8 on the module, which kind of bears relation to some of the things Tom was saying in the previous session about the approach to public law generally, and how we can decolonise it, as well as Fred talking about contract law in relation to the sister module to this module, which is W212 earlier. If we move on to the next slide, please, Carol. Thank you. And part of what Carol mentioned earlier, the transparency, is the unit opens with sort of talking to students about what we're trying to do to some extent. Do we need to study the empire in order to understand the Constitution? What can we learn from it? History is contested. History evolves over time, and students don't have to agree necessarily with the approach, or but you know, can be open-minded to different perspectives and think critically and reflect on different perspectives, and may enrich our understanding. And there's some discussion in there of the idea of Orientalism, introduction to some of Ed Said's work on that. And then building on that, talking about the choosing the constitutional law and the history that we study, selective history, selective law, writing with reference against some resources from David R. Sugar and Amira Savaratnam from the Imperial War Museum. The video discusses that and links it a little bit to the idea that, you know, the sort of recent statues controversy, and bring those in, just situating for students and to some extent confronting those gently but upfront as something that we are talking about in this unit. Next slide, please, Carol. So the way it approaches really looking at the history of empire is to some extent to what extent and how has it helped shape the current Constitution. Things have changed, and we sort of elsewhere disavow this continuity myth that Tom was mentioning earlier, but at the same time say, you know, the imperial period was significant for shaping how we understand the Constitution in a continuing way today. So look at a bit at how the empire was governed, a sort of pragmatic ad hoc approach to rule of the empire without a coherent system, and the importance of racism and racial distinctions in the way different parts of the empire were governed at different times and over time and at the same time, but also bring up this idea of being held together loosely in sort of Dicean terms by an imperial parliament that was supreme, and that was the thing that sort of joined the empire together legally, the ultimate supremacy of the imperial parliament, and why that continues to resonate today in English constitutional law, although to a slightly lesser extent in other parts of the United Kingdom. Next slide, please. So there's a little bit more, and this is mentioned earlier in the module from the textbook tradition, particular Dicey, but mention of one or two others from the 19th century, use of Dylan Lino's writings on Dicey to talk about, as I mentioned, the absolute sovereignty of the imperial parliament, the sort of flexibility and expansiveness, the potential for expansion, also laissez-faire approach of the central parliament to managing the empire, and running the empire legally, and the development of important conventions and how they operated in relation to the running of the empire as well, and how those again in some ways resonate in the modern constitution today. As well as some of the limitations on central power being practical and geographical, rather than legal. So risk of rebellion, I think the fact that places were so far away, and it was difficult to run the empire centrally. So how that kind of influenced both the way the empire had to be governed, but also the sort of the constitution, the development of the constitution, how it's written about in an ongoing and influential way. Next slide, thank you. And then we come to the end of empire to talk about decolonization and sort of a bit about how that process came about, and what, you know, how that sort of to some extent mirrors the way constitutional change continues to be made, and some of decolonization was obviously quite recent and some are still ongoing. And there's a discussion of those things in relation to the impact on the constitution in terms of the key principles of parliamentary sovereignty and the rule of law, with writings from Oliver and McBride there, and a bit more of discussion on the rule of law about this question, and like that term and interest me in another context as well, Tom, of legalized lawlessness, but the kind of dual role of the rule of law, this kind of narrative about how it was used and the way it was actually used, and the underpinning of it by force and violence, how it was used both idealistically and instrumentally, ultimately in ways that were there to reinforce the empire, however it was used. So we sort of touch on that a bit, and I'll just come toward the end. Thank you. Next slide, Carol, please. Oh yes, and just should mention there's some discussion then of the current constitution and how some of those legacies are continuing in sort of practical or concrete terms through the Crown dependencies and the British or UK overseas territories, and the way they are relate to the current constitution, the way they're kind of hidden away from the domestic constitution, but nevertheless part of it. There's some discussion of the Chagos Islands dispute, and coming to the end, sort of some encouragement of students to read some resources around the persistence of colonial constitutionalism, and consider to what extent, you know, the end of empire continues in the constitution today. Next one, please, Carol. So I think some of these benefits are known, and we talked about today, but we think the use of the historical approach benefits both through enriching interest, but providing context and perspectives, illuminating excluded or marginalised histories, enabling critical, interdisciplinary and non-doctrinal approaches and thinking, and encouraging and enhancing inclusion and informed debate and understanding. And finally, next slide, please. We feel, I mean, we're only like W212 a few months into the module, so we have no concrete outcomes yet, but feel this both improves understanding of the current constitution as well as developing important skills for students, legal, academic, noting that many OU law students don't come on to become practicing lawyers, but do other things related or unrelated to the profession. It's a wider range of relevant and interesting material, helps retrieve underrepresented histories and elements, and interrogate ethical issues relating to the Constitution as well. And I'll finish there. Thank you very much.